think if you look at the bottom left of your screen, Sherry, you'll see some icons where you can change your view.
Oh, okay, thanks. I had to swap out my computer at the very last minute because my sound card decided to die, so I'm using a laptop I grabbed from an adjoining office. All right, so what we're going to talk about today in the short time that we have together is the looming problem with dementia, what the elder law attorney's role is in dementia care, go through the ethical principles in the decision-making model, talk about the legal principles, capacity versus competency. What does that mean? We all have heard the term informed consent. How does that play out in the hierarchy of decision makers and scope of their authority? And then looking at capacity as a moving target in terms of, those different topics, informed consent, reception and treatment, some more interesting topics on using technology to track people and being able to consent to sexual activities and advanced directives. And then we'll look at a little case studies. I think people tend to find those more interesting, so I'll try to be mindful of the time so I make sure I get to those, okay? All right, so away we go. All right, so when we think about what the elder law attorney's role is in assisting clients, it's generally with, people usually think, well, it's estate and long-term care planning, it's asset protection planning and advocacy, but that's sort of at the higher level, that there really is this idea of the 4 C's of elder law ethics. And that's client identification, identifying any conflicts of interest, confidentiality, and capacity. And what I put on the slide is a really nice resource for understanding how elder law attorneys, work with clients. It's called Why Am I Left in the Waiting Room? And I think I put a link to it. And some of you have probably seen this already, but it's been around for a while. But it's a really nice guide to help explain how elder law attorneys interface with clients. From the outset, I'm always trying to figure out, what do my clients have capacity to do? And in the first instance, do they even have capacity to retain me as their lawyer, right? So oftentimes the person that calls me isn't the one that's going to be my client. Might be, an adult child, a neighbor, something like this. But in doing my work and doing our work as elder law attorneys, we always have to be mindful about who our client is. So, and it's not necessarily the person who's paying my bill. So it's really important to have an initial meeting with the client, with just the client, him or herself, to make sure they understand why they've come to see me, or in the case of Zoom, why they're staring at me on a screen, as we've had to do since the pandemic started. And I will say here that it has made it really challenging to do those sort of in-person meetings, having to ask family members to, can you step out of your own living room so I can talk to mom or dad, is it's obviously not ideal, but we have to do it. It's part of our ethical obligation to make sure we know who our client is and what they have the ability to do. And then, again, in terms of conflicts of interest, I always want to make sure my client understands that I'm representing them and not anyone else, and also making sure other parties understand who my client is. If I let everybody into the room, then there could naturally be a confusion about whose interests I'm representing. In the case of an elder law attorney, it's always going to be, almost 99% of the time, the vulnerable older adult. But that can get confused if the person says, well, I called the office, I made the appointment, mom doesn't know how to express herself, things like this. What we find most of the time is that our clients are usually able to express in some fashion, what is the nature of their legal problem and what they want to talk to me about. Now, will they remember every date and phone number and all? Maybe not, but that's not wholly relevant. I need to make sure that I have a client, and as long as they can communicate with me and want to communicate with me, we can have an effective representation. And then in terms of, capacity, we'll get into that a little bit more as we go through, but that is, what we're always trying to figure out is capacity to do what. So as I said, in the first instance, can they be a client? And then within that, what do they have the capacity to do? Can they do a will? Well, that's the highest level of legal capacity, right? You need to know what you have, where you want it to go, come up with an orderly, plan for its distribution, all of these things that are, in the set forth in the law as to what you need to have valid testamentary capacity. Not all my clients have that. Maybe they can just do a power of attorney or just a healthcare power of attorney. So it's my ethical obligation to figure out what they have the capacity to do, and we'll talk about why that's important. And then lastly is confidentiality. So when I'm meeting with my clients, I'm always making sure that they understand the scope of the confidential relationship and making sure that they're giving me informed consent about who I can share information with. So while I might ask somebody to step out of the meeting at the outset, if the client says, I'd feel more comfortable and I'm okay with you sharing information with my daughter, and I've learned from meeting alone with my client that there is, there really, in my opinion, there's no problem there with the daughter being involved. We can bring that daughter in, and then we can expand the idea of confidentiality in some instances to include sharing all information with the daughter. So normally I would say any questions about that because I'm used to a live audience, but hearing none. So let's go over here. So I always like to look at charts and statistics and things. So I hope you do too. So I'm going to go through some right now for you because it really is a looming problem. Everyone who's at this symposium today knows this, and I'm sure it's been brought up in many other presentations today. But I just wanted to kind of walk through why I'm even doing this kind of presentation, right? Why do elder law attorneys care about this stuff? Well, I think this picture kind of says it all, right? Like, even if you don't like charts, you can see that this is a pretty troubling picture of where we expect Alzheimer's disease to go by 2050. Okay. The number of people is going to increase dramatically in the next 30 years unless there's preventive measures or there's effective medications. There's talk of a vaccine, but right now there's really nothing preventing this from this occurring. We know that Alzheimer's is not a normal part of aging. It's an irreversible degeneration of the brain that causes disruptions in memory, cognition, personality, and other functions that eventually leads to death from complete brain failure. So this is a really grim picture indeed. We know that a large segment of the American population has begun to reach 65, and by 2030, the segment of the U.S. population age 65 and older will increase substantially, and the projected 74 million older Americans will make up over 20% of the total population. So we know that as this chart is showing, as the number of older Americans grows, so will the incidence of Alzheimer's disease. Okay. So just some additional numbers for you again, just so you know, I want to cheer everybody up today. There's 5.8 million Americans living with Alzheimer's disease, and again, it's expected to rise to 14 million. Every 65 seconds, someone in the United States develops the disease, and it's the 6th leading cause of death in the United States. And 1 in 3 seniors dies with Alzheimer's or another form of dementia. There's also global impacts, so we've been focusing on the U.S. At least 50 million people are believed to be living with Alzheimer's disease or other dementias. Again, it could exceed 152 million worldwide if nothing's done to really stem the progression of the disease. This is really a grim one too. In the time it takes to read this sentence out loud, another person somewhere in the world has been diagnosed with dementia. Every 3 seconds, or in the time it takes to blink twice, someone in the world develops dementia. So there's some uplifting stuff. Is there any good news? Oop, why isn't this working? Oh, there should be. Now it's decided to stop working. Oh. Sorry, got some crazy dialog box on this computer. Here we go. So in May of last year, there was a new study published in the Journal of the American Medical Association, finds that for the first time, technology can detect biological evidence of brain changes linked to Alzheimer's. This is important because getting a correct diagnosis can help a doctor prescribe the correct medication, and patients and families can access appropriate resources for how to, deal with the disease, maybe access legal services if they haven't done any planning. The prevalence of planning is generally, in my view, not something that a lot of people do proactively, right? So it's a diagnosis oftentimes that gets people in the door to see me. I always joke with my clients that no one ever wakes up and says, I'm feeling great today, I'm going to call my elder law attorney. It's usually that there's some dire need, a diagnosis, someone needs to go into a nursing home that finally kind of compels them to take action. So if we have earlier tools for detection, hopefully that can get them into my office sooner, and we'll go into why that's so important in a minute. And then it's also important having these advanced clinical tools to make sure people are diagnosed accurately. By using PET scans, it found that this particular study that 1/3 of patients had actually been misdiagnosed. That's a good thing, but unfortunately, where technology meets payment systems, right? So PET scans are generally not covered by Medicare or most health insurance plans, and they're really expensive. But the technology is there, and there's some hope on the horizon. There are still no treatments that have been, as I've said, shown to reverse the process once it's started. There is a research project underway at the University of New Mexico for a vaccine that could help to prevent Alzheimer's disease. It started back in 2013. It's been tested on mice, but it hasn't been shown if it will work in people. But there is, there are things that are happening. I always recommend folks to go check out the Alzheimer's Association. Online has a great deal of resources and information if you're really interested in learning more about what's being done from a medical technology perspective. Okay, so we'll just go through here. The common causes of dementia is 60 to 80% of all cases are Alzheimer's disease, vascular disease, about 5% to 10% of the cases, and Lewy body disease is another bit. We know that there's also a number of things that are reversible that can cause Alzheimer's-like symptoms, things like infections or a brain injury or things like that. So side effects of medications, emotional problems like depression, stress or anxiety, vitamin deficiencies. So it's really important to understand, what we're dealing with, because as we'll talk about in a minute, when we apply the legal system to it, we want to understand what is the nature of the person's condition in an expert's opinion. Is it expected to improve? And if so, what types of remedies do we want to apply to make sure that we're preserving patient autonomy and dignity? And I should also point out that there's this idea also of mixed pathology. So we have these types of dementia, but you can have more than one, right? And sometimes you can have, dementia due to alcoholism and some of these things. So it's really, again, really important to understand what's causing it. And then it also lets us know how we can address it from a legal point of view and from a clinical point of view. So, all right. Next, we're going to go into looking at some of the ethical principles. And there are 4 tenets of bioethics that kind of underpin everything we're going to talk about today: patient autonomy, beneficence, non-malfeasance, and justice. The growing number of individuals affected by dementia will intensify the need for ethical guidelines and training and best practices for caregivers, clinicians, everybody who's working with patients with a dementing illness, that we really should be ideally guided by ethical principles. In terms of healthcare, the practice of medicine is directed by clinical practice guidelines, or CPGs, and in theory, they contain all the evidence-based information of the benefits and harms of various care options for any given disease and are well studied and used by caregivers in clinical settings. And they do include some elements of ethical decision making, typically based on the 4 agreed upon tenets of bioethics. So patient autonomy is preserving the rights of individuals to make decisions about their own lives, otherwise known as self-determination. How many of us remember thinking as a child, you're not the boss of me, right? And the feeling of powerlessness and frustration that was the undercurrent of that expression, right? So when we think about, people with dementia trying to exercise their own self-autonomy and others coming in, perhaps, and usually, good-heartedly trying to help, there's a natural tension there, right? And that's where we want to, when we're carrying out our duties as family caregivers, I think, and understandably, we can get really focused on the outcome. We want you to get dressed. We want you to get in the car. We want you to get in the shower. But, we've also got to think about it from the person's point of view, right? This person was at one point an independent person with full cognition, right? That is what the devastating impact of these diseases are on anyone who gets them, right? That you go from being an independent person able to do everything for yourself, now not being able to do things for yourself and having everybody else point out all the ways that you need help and all of your deficiencies seemingly all the time, and you don't remember why, right? So as we're thinking about this from an ethical perspective, if we're grounding our approach in the idea that patient autonomy is so important, it really allows us to adjust our behavior when we're seeking to help or provide services to that person. We think about beneficence, it's the duty to promote the good of the patient with an emphasis on shared responsibility. So making sure that we're including the person in the process, right? We're not trying to just do or impose our will on them because we know what's best, but in making sure that they're actively participating in the solution to the extent they are able, not encouraging excess disability, right? Helping people to do things that they could do for themselves, and then eventually they lose that ability. Well, then we have non-malfeasance or do no harm. And finally, justice, assuring that there's an equal access to care and that there's a fairness of distribution of goods and services. And obviously, as an elder law attorney, that's very much important to all of us that do this work, is making sure that our clients are getting the care that they need and the setting where they need to be, and that they're able to access payment systems to help them get their care covered, and to prevent the downstream effects of that, like spousal impoverishment. So really, as we're carrying out our work, there's all these things going on, and I'm sure everybody who's taking care of an elderly person kind of knows about this on some level, but these are really sort of the organizing principles of decision-making theory. And so we know the principles are great in theory, but they muddy up quickly when a specific disease such as dementia doesn't necessarily play well. But it remains important not to divorce clinical practice from ethical practices, that we always want to be mindful of this tension of patient autonomy and beneficence. So our first step in working with family caregivers is expect them to have these principles really internalized, or do trainings and things to make sure that they have this internalized, because caregiving is really hard work. It's really frustrating, and it's okay to have feelings as a caregiver, right? I tell every family that comes to see me, they usually put the person with a dementing illness, again, when we get to see people in the office, at the head of the table, and everybody else kind of steps aside as though it's not, or the wife who is healthy, it's usually the husband, but you never know. The healthy spouse will say, we're just here for him. And it really is for everybody, that my work is really to make sure that my caregiver spouse is getting the support that they need so they can help preserve, promote the autonomy and independence of the person with the dementing illness. So that's really how I work with clients in terms of interfacing with them on these principles. Okay. All right. Let's make sure this works. We're kind of running short on time, so I'm going to get to the legal principles. Okay, so I want to go through the idea of capacity versus competency, informed consent and sound mind, the hierarchy of decision makers, and the scope of authority of surrogate decision makers. Okay, so capacity is generally a medical decision, where competency is a legal decision. And then to make things even more confusing and complex, under Pennsylvania law for guardianships, they refer to an incapacitated person, but what the court is doing is making a competency determination. But either way, when we're talking about capacity or competency, the underpinnings are exactly what we've just been talking about: self-determination and autonomy. So capacity is a functional assessment made by a clinician to determine if a patient is capable of making a specific decision. So as we know, capacity to make your own decisions is fundamental to your own autonomy. And, when when a clinician is evaluating a patient with dementia, they're trying to assess, can they do specific things? And that they understand that capacity can be a bit of a moving target. Can the person give consent, informed consent for procedure? Well, they might be able to in the morning, but not in the afternoon, right? So you want to make sure that we're revisiting these questions repeatedly, right? To make sure that we are making sure that the person has the capacity to do what they say they want to do. If a person is without capacity, then of course, then we need to get into the next bit about who the substitute decision makers are going to be, and there's lots of law on that, and we'll get to that in a minute. And competency is sort of the legal equivalent of the capacity determination, and that's usually determined in court by a judge. The burden of proof is on the person alleging that someone is incapacitated, because under the law, unless proven otherwise, we are all presumed to have competency, legal capacity. And the end result of a finding, as we'll see, that you don't have competency can be pretty disastrous for the individual, in that they lose all of their rights to make all of their own decisions. Okay, so when we're looking at this, so if we think about, we've come to this decision that we think that somebody doesn't have capacity to do, say, a healthcare power of attorney or a financial power of attorney, wherein the person themselves can name another person to act on their behalf in a legal document known as a power of attorney. So that person who's acting on their behalf is known as the agent, right? So at a minimum, we're always trying to make sure, do our clients have the ability to make that choice? It is so crucial to their own autonomy to be able to make that choice for themselves. A lot of times I'll get calls in the office, and I've been doing this for 17 years now. We get a call just about every day from somebody saying, hi, I'd like to get power of attorney over my mother, right? And we understand, probably everyone on this meeting, is that power of attorney is not something you get over somebody else. It's something that is given to you by an older adult with legal capacity. So if they don't have legal capacity, so if someone calls me and says, my mother was diagnosed with Alzheimer's 10 years ago, is nonverbal, doesn't move, and decisions need to be made, then we're looking at moving into the guardianship system. Now, the guardianship system is, as most of you know, run through the orphans court in the relevant county where the alleged incapacitated person lives. And again, I use that word alleged because this is a full-blown court proceeding. It is not something that is done quickly, easily, or inexpensively. There have been a number of improvements to the guardianship law, mostly in response to some pretty horrific instances of abuse by guardians. But what that means is that there's a lot of process and procedure that people seeking guardianship over somebody need to go through. But it is all aimed at preventing abuse. So in this, under the law changes and there's new forms and reports and things, they're really wanting to make sure that guardianship is used as the alternative of last resort. The person who we are seeking to get guardianship over must receive due process. They must get notice of the hearing, right? Because it's going to be before a judge, and given notice that they have a right to counsel. They are compelled to appear before the judge, and it's really ratcheted down with the change in the law as to how you can kind of get out of that, right? So before, you might be able to say, well, the person wouldn't understand, they have dementia, they have this diagnosis. Now there really is a lot more that needs to be shown to the court to explain how the person will be harmed by their appearance, right? So it's not just that they won't understand what's going on, is that you actually have to show the judge that there's going to be harm to the alleged incapacitated person. All these things, again, making sure that we are using this tool as one of last resort. If we look at Pennsylvania law, we see that it's possible and even preferred under the law to have a limited guardianship over the person, so where you're not taking away all of their rights. However, in practice, that's not usually the case. It's a global, assessment that they're not able to meet the essential requirements for their own physical health and safety, or they are unable to manage their own financial resources. And if a court determines that this is the case, then we have the appointment of a permanent plenary guardian of the person and the estate. Now, I say permanent, but we know that we talked about already, capacity is a moving target, and autonomy and self-determination are the tenets of this work. So there's always the opportunity for the person, even once adjudicated incapacitated, to return to capacity. So when we do reports as guardians, once you become a guardian, there's a series of reporting. Again, part of the enhancements to the guardianship rules that were implemented in the last few years. There's detailed reports that need to be filed online about the person's, well-being, and how often you visited them, and what activities have you done, how have you handled the incapacitated person's assets and things like this. And there's always a question: is should this guardianship be continued, right? And why? So they're always checking every year through the filing of these reports to make sure that this guardianship is something that should be continued. And as someone who serves as a professional guardian, that's something I'm always thinking about. Is there an opportunity for my client to not have a guardian, right? Do they have the ability to do a power of attorney at this point in time? So that's how it generally works. For the most part, I think people who go through this process and are adjudicated rarely, but do, get restored to, particularly if they're an older adult, to a full capacity. But it's important to understand that that does exist in the law because of the preference for autonomy and self-determination, that it is really baked into the system. So when people call my office thinking like, oh, we'll just get guardianship over Aunt Sally, she's got Alzheimer's, not so fast, right? We have all these provisions and protections in there to make sure that guardianship is being appropriately imposed in the first instance, and then appropriately continued as you go along. All right. Any questions out there? Are people are they awake? Hard to know. Okay. All right. So I think I'm on the right side. Now that I've given kind of an overview of the idea of capacity and competency, I want to get a little more granular for a minute on the elements of decision-making capacity. There are 4 key elements related to decisional capacity. They're first described, and I gave a little citation there, Grisso and Applebaum in the New England Journal of Medicine. Can the person communicate a choice about a preferred treatment option? Do they understand the information that's being provided? Can they appreciate the situation and its consequences? And can they reason through those things rationally? A person is without capacity if at the time the decision needs to be made, She is unable by reason of a mental disability to make a decision on the matter in question or to communicate the decision. But again, people with dementia, we have to understand that their capacity can be variable, right? So we don't just want to say, hey, they have Alzheimer's disease, game over, right? We're always wanting to assess these elements of decision-making capacity every single time, right? We're not just writing somebody off and deciding that they can't participate fully in their own treatment decisions. That all of this ethically, we need to go through these items to make sure that we are involving the person to the greatest extent possible. And so one of the ways that we can do this, obviously, is through clinical assessment tools, patient interviews, and things like this. So they're really, those will go over here. So we can, and so the idea is, well, do we have to do a formal capacity assessment for everybody? Well, no, it's reserved for situations where we're concerned about the decision that needs to be taken. Sometimes an informal assessment is perfectly okay. So if I'm working with a client who's in a nursing home with a diagnosis and we're chatting and I'm a little concerned about, and I want confirmation that my opinion, and as a lawyer, I do get to make an opinion on this, whether I think they can do a power of attorney. I might bring in my social worker to do an assessment, ask them a series of questions. We include the mini mental state exam, mood scale, things like this. And so I can understand, and have, something to rely on when I, make the decision or not to assist a client with doing estate planning documents. And again, why do I go to all that trouble? Because the guardianship system, as we've just heard about, is not something I want somebody to enter unless they absolutely have to, right? So we want to make sure as lawyers that we're using tools, and as even clinicians that we're using tools to make sure that people do have the ability to make decisions, and understanding that capacity runs in a it runs in a continuum, right? It's not I think the analogy usually is it's not a light switch, it's a dimmer switch. So, some people might have ranging from adequate to marginal to inadequate. So some of you right now by this point in the presentation may be feeling a little tired and marginal. But once I'm done, you'll feel really adequate. So probably not the best example, but you get the idea. So it's just really important to always have these guiding principles of ethics in your mind when working with clients and patients.
Sherry, we do have some questions in the chat now. I don't know if you saw them.
I am like the only person I can see is you. So if you want to just tell me what they are.
Sure. I'd be happy to. Okay. In regards to a client's capacity, how do you manage a client who verbalizes an understanding of something, but in your opinion or observation does not actually understand something, and how do you proceed?
Wow. That's a great question. What I usually do in that situation is I would bring in my social worker to do an assessment. We would talk, sometimes she would talk to the doctor and things like that, but we would never proceed if we were concerned about capacity. A power of attorney is a wonderful document, but it can also be a fantastic tool for abuse. So I would never want to just sort of proceed if I ever had a hesitation about somebody's ability to proceed. Hope that answered the question.
Great. Yeah, I think so. What if the family cannot afford to go through the guardianship process? What alternatives are there? This is from someone who's working with a daughter whose father has dementia and cannot express his wishes, and she has no access to his financial information. He's unable to grant a power of attorney document at this time.
Mm-hmm. Well, so there's a couple things in terms of if they have no money, if the alleged incapacitated person has no money, then there are free legal services available to indigent adults. Community Legal Services, Senior Law Center, great resources to look for that. The local bar association all offer lawyer referral. If there's a chance that there's that it's an access issue and a lack of information issue. There is money, right, but the person just can't get access to it. Well, then, the legal fee is generally having to be approved by the court anyway, so you don't necessarily have to pay up front. So if you suspect that there are assets out there and it's just a question of getting appointed to be able to access them, that, you should, do your best to try to get some information, but there are free legal, resources out there for these situations.
Great. Yeah, I know legal aid from Bucks County is a good support as well. If a guardian believes an individual continues to need a guardianship, but the individual or caregiver or family member disagrees with the guardian's opinion, how is a reassessment sought?
The person who is alleging, that, so the family member or caregiver in your situation is saying, you know what, I don't think they need a guardianship anymore, they can petition for a review hearing in the orphans court. And what that'll do is bring all the parties in. The court will generally appoint a guardian ad litem to do essentially an investigation. And they can also bring in a psychologist to do a new assessment. And then that person, the guardian ad litem, armed with that assessment, reports back to the court and gives his or her findings about their opinion of whether the guardianship should or should not be continued. Yet it is always the judge who gets to make sort of the final decision. But that would be the process.
Great. Okay, there are 2 more questions so far.
Oh, good. All these people I'm glad everyone's paying attention. Thanks.
Yeah, they're out there. They're out there. Okay. Is it a red flag when families want to get power of attorney, but are in the same breath insisting the older adult is unable to make the decision? Also, it concerns me that a power of attorney can be downloaded from Google and signed. Are notaries required to complete a sort of capacity evaluation before notarizing a power of attorney that was not produced by an attorney?
Great question. Yeah, the LegalZoom power of attorney that you can just download, I think it's $39. And the legal impact of it is about that too. It can be a tool for abuse. Can somebody download a power of attorney from LegalZoom, take the person to a notary, have them sign it? Yeah, that absolutely can happen. The notary is really under no obligation other than to say that this is the person appeared before them and are who they said they were, right? So it is a little bit concerning, that can occur. The notaries don't have any obligation to do that. What was the first part of the question? I feel like I'm missing something because I'm not seeing it.
Yeah, let me just back up real quick. Yeah, I think first there was concern about the family seeking the power of attorney.
Right. I don't know that it's necessarily a red flag. Was that the term? Is it a red flag?
Yes.
Flag? Is it a red flag? I don't know. Maybe it's a pink flag. I don't know. It's, I'm always worried, like we talked about at the beginning, like who's my client? I always need to understand who my client is and do they have capacity to be my client. But most of the time it is the family member who's compelling the older adult to come see me in the first instance, right? Like if they're 87 years old and they never did a power of attorney before, it's probably because they didn't view it as something that was important or that they wanted to do. And they're sort of being brought to the understanding that the kids can't help them in the way the older adult would like without this document. So, and then by that point, the older child, the adult child, is already in a position where they're doing so much to help. So it's not necessarily a red flag that they're sort of driving the bus initially, but it's sort of once it hits, my office, it's our job to make sure this is something that the older adult has capacity to do. But lawyers, we're always looking for red flags, right? We're always assessing risk. Does this make sense? Downstream effects. That's a part of it. So I would say again, it's not necessarily a red flag. It's pretty common, but it's definitely something. We all know that there are bad apples out there, right? That will download a power of attorney off LegalZoom and drag Granny to the notary to get it done. I would say, fortunately, I don't know that that's, fortunately, it's not terribly common, but is it possible? Absolutely.
More questions are rolling in, and I'm kind of wondering what you'd like to do. Would you like to go on with the questions or go
Yeah,
on
why
with the
don't we
presentation?
do, or why don't I do, well, how many more are there?
Well, every time we finish one, another one rolls in. So, which is a great thing.
It is
I
a
just
great
didn't know
thing.
if you wanted to get through some more information and then hit questions toward the end,
Yeah,
or if
why
you
don't
wanted
we
to
do
keep
that's
going.
why don't we do that? Because I would hate,
Okay,
I'm
I'll
so
keep track.
thankful for everybody for asking questions because it makes it feel, even though again, due to technology, I can't see you. It makes me feel like you're out there and I'm not just talking to the walls in my office. Okay. So thank you, thank you. So keep the questions coming and I hope to be able to get to all of them. Okay, so we'll just look really quickly and I'll sort of try to, knowing that there's questions, try to kind of hit the highlights on some of these things. So I just wanted to go over, I think we've all heard the term informed consent, but it's, do we really want to make sure we understand what we mean by that? It's definitely the cornerstone of bioethics and it's protection of the rights of medical patients. And we know that no treatment is supposed to be given or research conducted unless the patient um, gives you informed consent. And what does it mean if you haven't given informed consent? Well, that's actually an intentional tort. It's battery. We know that from the case law that when somebody hasn't given you their express approval and consent to conduct a medical treatment on you, that actually can be actionable. But we know that the doctor must describe the procedure or the treatment, explain the risks and benefits, discuss alternative treatments, and then hopefully the person has capacity in the first instance, right, to be able to make the decision that that is being called upon to be made. There are some exceptions. So, if somebody, and this is a big one, the emergency exception, I get asked about this a lot. If somebody's brought to the emergency room and they're unconscious, well, they can't give informed consent. You're right, they can't. They're unconscious. But if in a doctor's opinion that treatment needs to be done to save a life, then then that's going to happen in the absence of countervailing circumstances. Like we see that the person has like a DNR necklace on, or they're known to the doctor. But if someone comes in a car crash and they can't express themselves, the doctor can't say, well, I got to wait till they wake up to get their informed consent to treat. Well, no, there's the emergency exception. And then there's also this idea of an extension doctrine. So maybe the seminal case here was, they were doing surgery on a woman that she consented to, and they found something else when they were in there that was going to be life-threatening. Did they have the ability to go and continue on with that treatment? The answer was yes. If they feel that makes sense for, the scope of services that were originally consented to. So if we have somebody that has informed consent and capacity, we roll along, right? The patient and the doctor relationship. The doctor is, observing all the tenets of, bioethics, and there's, respecting the patient's autonomy and all of this stuff. The patient is given all the information they need to make an informed decision, and it all goes right as rain. But what happens if the person doesn't have capacity? What do we do then? Well, then we have to look to alternate decision makers and then figure out which ones and in which order, right? And that's where things get fun and interesting. Okay, so we know by now, because I feel like I've said it to the point of probably boring you half to death, that we believe in patient self-determination and autonomy. So the patient is always going to be at the top of the tree. In our hypothetical, though, we've said, our patient doesn't have the ability, doesn't have capacity, can't give informed consent. So who comes next? Well, if there's been a guardianship proceeding, then the guardian of the person is going to be the one to make that decision. But wait, there are limits, and we'll talk about a case. Next is the agent under the healthcare power of attorney for healthcare decisions. Pennsylvania has the idea of a healthcare representative, and then we talked about what happens if it's an emergency. It's the medical provider. So I think, most of us understand the idea of a healthcare power of attorney, like we've already talked about. The patient, him or herself, when she's feeling ducky, or maybe sometimes not so ducky, but can still make decisions, has capacity to do a legal document, names person or persons to make legal decisions for them. Now, a question I get asked a lot is, well, who should I pick, and can I name all four of my kids? You can name all four of your kids. I generally think it's a pretty challenging thing to do, because now you've got four people who need to agree, and tensions and emotions might be running high at the time a healthcare power of attorney needs to be used. So it really is better to be thoughtful in the first instance and really think about what child or children, maybe pick two, who would be best positioned to know what your healthcare decisions are, what preferences and doctors and all of this, and have them be the ones that are authorized to make your healthcare decisions for you. And then if you're worried about, well, Susie will be upset if I didn't put her name down. Well, you can put her name down. Just make her a successor agent. So we do that sometimes. So if you still want to put all four kids down and you want two of them, one's a doctor, one's a nurse, just for example, to be the two at the top, and you can do sort of a decision tree, going, if those two fall down, then we can name the other two kids. Their name is in the document, so no feelings are hurt, and you've made a good decision, but who would be the best people to make healthcare treatment decisions for you, who would do what you want, not what they want, right? So just a pause here on what it means to be an agent, right? So we all know that agents are fiduciaries, which means they have a duty of care and a duty of loyalty, that they need to act reasonably and prudently at all times, and they need to act in the best interests of their principal, not themselves. So if upon hearing that definition you go, oh, I don't know that I picked the best people for my power of attorney because I just went in birth order, that happens all the time. You really do want to think about it like you're hiring for a job. And just because Joey was born first doesn't mean he's going to be the best one to make your healthcare treatment decisions for you. Now, we've talked about guardianship as being, this disaster situation, and I think that it's a tool, right? So, if we need to use it, I'm glad that it's there, because, it's definitely a way to get somebody appointed for a vulnerable older adult who needs assistance, but I would never want to start there. And Pennsylvania has given us this idea of a middle ground. So if we haven't done a healthcare power of attorney and we don't want to do guardianship, there's this idea of the Healthcare Representatives Act. So this gives us a pecking order of, in the absence of a document, who can make the decision for the patient. Now, we don't want to rely on this, right? Because particularly if we've got children all stand in the same class, in the same of the pecking order, right? So we have the spouse and a child who is not the child of a spouse. So if it's a second marriage situation, your biological child and your second spouse or third, who knows, are stand in the same order. So already right there, we're building up for conflict, right? So we never want to rely on this. And then it's adult children, and it's a vote of the majority. So it's great that this is here, because it's better than having to go through guardianship, but we can already see that it's sort of rife for problems and already undermining the idea of self-determination and autonomy. You're kind of leaving it up to the peanut gallery to make really important decisions about your health care. But it's nice to know that we have this for clients. Maybe they have nothing, there's no assets. We just want someone who's able to be recognized as the authorized decision maker of a statute can be very helpful, and gets us out of having to go petition the court for a guardian of the person. Okay. So we talked about the protocol. The decision maker should always seek to carry out the patient's expressed wishes. And they should understand, what the person would or would not want, ideally based on conversation. So I always tell clients, we can do legal documents all day long, but if you haven't had the conversation with your family members about what it is that you would want, when the who hit the proverbial fan, the documents are of limited use, right? The people need to know what it is that you would want to do. Just moving forward, this case, and I want to pause here for those we can send along this PowerPoint. We have some other resources. So if people want to provide an email address, I guess through Holly or
Yeah, I think actually if you just forward the content to Holly,
and
she's
she'll
going
get
to
it
work
out to
with the
everybody.
college to get it posted. Yeah.
Yeah, so I'm gonna, because I want to get back to the questions, but so all of this can be, emailed to you by Holly if that's what you like. But this is an interesting case that talks about, so now we've talked about, okay, who can be authority, what can they do? So this was an interesting case in that, did I go past it already? Where parents were appointed the guardian of their adult child who had, was developmentally disabled, had been living in a state facility for his entire life, and he had an incident where he somehow swallowed a hairpin. He wasn't end of life, and he was put on a ventilator just to help him because he was aspirating. And the parents went to court to argue that they should be allowed to, on his behalf as the substitute decision makers, because they were guardians, remove the ventilator, and they were turned down. The court felt that they did not have that authority as guardians. Now this was kind of an interesting one, in that I think most people thought if the statute had been interpreted in a different way, that actually guardians should have this authority. But in this case, actually, they kept the ventilator on. He was an end-stage medical condition, or in a permanent state of unconsciousness, which are the two criteria for end-of-life decision-making to kick in for Pennsylvania, right? So we know we have the idea of a living will, where we can say we do or do not want life-sustaining treatment at the very end of life, but you need to be permanently unconscious or in an end-stage medical condition where a doctor determines that your death is imminent. This guy was not, and he actually recovered. But it was an interesting case from at least from a lawyer's perspective, in terms of the scope of a guardian's authority, and actually kind of created a little bit of a gray area. If he had been in an end-stage medical condition, it's thought that they probably would have gotten the authority, because underpinning all of this is the idea, the state's fundamental interest in preserving life, right? So that's the tension that was at play here. So so we think about guardianship and it's control over everything. This case is sort of instructive and is saying, well, not so fast. It's not just carte blanche to do whatever you want. Then there's this idea of the countermand of informed consent. A principle of sound mind may countermand any healthcare decision made by the principal's healthcare representative at any time and in any manner by personally informing the physician or healthcare provider. So this kind of puts us in a little bit of a sticky wicket, where the agent's making decisions and the principal says, hang on, that's not what I want to do. And now we have this reevaluation of capacity, right? Because because the healthcare agent's authority by definition only kicks in when the patient is incapacitated. So it is possible, right? So this idea of having a healthcare agent isn't sort of an overriding of the principal. When we go back to our hierarchy, who is at the top? The patient, right? So that's why we have this idea of a countermand, right? So the attending physician then has to let the agent know, like, hey, here's why we're not doing it. But it doesn't necessarily mean that the agent's authority is terminated, right? Because it's just as to that particular decision. So it really kind of brings to mind the idea of, healthcare being a series of decisions, right? And capacity being capacity to do what, right? It's not just a yes or no, an off or an on. That there are these restrictions, even though we can appoint a decision maker, there are some limits on what the decision maker can do, and the principal can override, if the principal wants to. Does it happen all the time? No, but it's good to know, that it's in there, because I think a lot of my clients who come to me are always worried, right, about giving somebody, too much authority. So we always remind them that you're at the top of the hierarchy. And if you're really worried about, what's going to happen if you're incapacitated, you want to make sure you're picking the right person and that you're having really serious conversations with them about your healthcare treatment preferences, even if they don't want to have those conversations. There's a resource I refer my clients to called the Conversation Project, and I think it's at the conversationproject.org. And what it does is it gives a lot of information, but what it does is it gives you a series of prompts as, say, the older adult. And I'll pause here to say that all of us who are adults attending missing should be thinking about having our own healthcare directives in place. I finally did mine 2 weekends ago. I had a free moment, decided to do my own documents. I know, right? In this case, the cobbler had no shoes. But the idea is it gives you these prompts. So I think a lot of times my clients, find it hard to start the conversation, or their kids are like, let's just go have lunch. And so it sort of gives you tools for overcoming objections, how to start the conversation, what to say. There's also the idea that I think most people are familiar with the 5 wishes document. Again, it's something tangible that you really detail that you can go through with your family member. But having those discussions really, I think, goes a long way to avoiding these sort of conflicts at the bedside, right? That if everybody's on the same page, we're going to have a smooth transition as we move along the continuum of care. All right, how are we doing for time? Oh, it's 2:25 it ends, right?
Yes, yeah.
Yes. All right. So I want to see what I want to get to. So why don't should I do, I'll do another few minutes and then we'll do questions for 15 minutes? All right.
I think there are just 2 or 3 questions at this
Okay,
point.
cool. So then I will keep going.
Yep.
Let's see. I think we talked about some of this already. Again, that consent requires that a patient has capacity, and that's usually determined at the bedside by the physician or the clinician. But again, not assuming that someone with dementia has impaired capacity, and that you want to make sure that people, again, we're following the hierarchy. And if they haven't made a decision, it's never too late to do planning, right? So even, unless it is, but I mean, in terms of, I had somebody just the other day, I think they were in their 90s. We finally did documents for them, right? So we didn't just write them off, oh, they're too old. We still were able to get things in place for them. Just kind of go here. Okay. Let's kind of go toward, I just don't want to get too bogged down in this stuff. Oh, I think this is a good one. This is one that a lot of people ask me about, is the idea of lie. Is it okay to lie to somebody with dementia? So there have been studies, a lot of studies on this issue, and it's really fascinating. Google it and go down a real rabbit hole in terms of learning more about this issue. But there's the idea of deceptive practices being pretty widespread in the care of in care settings for people with dementia. But there's not a lot in the literature, but there's some interesting things. Most come out on the opinion that lying to a competent patient is never acceptable, right? So we know if someone's able to, understand what we're talking about. So why would we ever want to do it? Well, there's this idea of a therapeutic lie. So there's an example of, say, we have a widow with dementia in a locked memory care unit, right? And she every day at 4:00 she sundowns and begins to frantically bang on the door of the ward, trying to get to her husband, right? She's a widow. He's passed away many years ago, because she believes, quite to a degree of high upset to her, that he'll be very upset if she can't get home to make him dinner. Then the staff reminds her, initially, oh, your husband's dead, has been for a long time. Don't worry about it. Come back. That distresses her even more. So the honesty, right, is actually compounding the problem. So the idea here with the therapeutic lie is it's kinder, it's more beneficent to say to her, your husband's at the store, but he'll be back soon. Why don't we come over here and wait, right? Solves her, the behaviors of the banging and the screaming, calms her anxiety and redirects her. Is that a lie? Of course, yeah, it is. But we need to kind of balance it in these cases. So as you can see, this is why I think it's interesting. It's, these things aren't really sort of black and white, and you could probably spin 1,000 permutations. Well, what if you said this? What if you said that? Is it okay then? Is it okay then? I think at the end of the day, when we go back to the foundational principles of what we're trying to do, we're trying to do no harm. We're trying to protect people, but also honor their own dignity and autonomy. If we're threading what we're trying to do, through that lens, through that needle, I think at least we're thinking about it in the right way, and we're not just, sort of lying to someone because, she's banging on the door and I want to get out to lunch kind of thing. So the idea of a therapeutic lie is very, interesting. We also see it in things where, a lot of our clients, should come to us at a point where they shouldn't be driving anymore. And so there's an example of, the wife will argue with the husband who wants to drive and say, hey, you're not supposed to be driving anymore. The doctor says it's unsafe. You have dementia. You don't know. Remember the time you got lost, and they get into a really big fight and he strikes her, right? So do we want to encourage that spouse to keep going around with somebody with dementia who's not going to be able to remember? Or do we want to just have her say, keys were lost, the car's in the shop, right? Is it a lie? Yes. But we got to think again, balancing it with the, with the ethical rules that we've been discussing. I mean, there's always the concern that lying is a form of paternalism. So this isn't something to do, blithely. We want to be mindful of that. We don't want to just, use it as a form of control or a technique to get our way over people. And there's some people who say, I will never feel comfortable doing that. Okay, I mean, I can see that too, but again, I think this isn't a black and white issue, right? I think there's some really good instances where it's the kinder thing to do, because we know also in these situations, if the person was able to appreciate that their husband had passed away, if they were able to appreciate that they weren't able to drive anymore, would they do the same types of actions? Well, of course not, right? So we're sort of in a weird way honoring who we knew them to be as people, right? So we're saying this is what's going to get them to take the decision that we knew that they would take, but for the dementing illness. Okay. So there's some guy, and you'll see all this, lies should only be told if they're in the best interest to ease distress. There's a whole chart here. I won't go through it because we're a little short on time, but it really kind of lays out some arguments about why you would think about using what are essentially deceptive practices, but that at the same time can be beneficial to the patient with dementia. So this idea of using technology for tracking for people with dementia, and I have teenage daughters, so I'm all about tracking. No, just kidding. But, there is this idea of, how much surveillance is necessary. Do we want to have a camera sort of trained on Granny at all times because we're worried about what will happen? Again, this idea of balancing her right to privacy and self-autonomy. There's even talk about, could we embed like little microchips like we do with pets? I think that's a really horrific idea, but it's definitely something that's being discussed and has obviously the ethical components to it. Does it, on balance, does the infringement on the person's liberty and privacy, is that outweighed by our need to make sure that they're kept safe? So if we think of somebody with Alzheimer's disease who could go out sort of wandering and get lost, well, it's not a clear cut answer. We have less intrusive things like safe return bracelets and wander guards and things like that. But it's really interesting to think about the implications of technology and how that can really cut against our loved ones, right to privacy. I know right now, if I wanted to, I could drop into my home, voice of God-like style, and ask my kids what they're up to. I try not to do that too much, but again, the technology is there, and with every technological advance, we need to understand the ethical implications of it. Are we using it wisely, and are we being too paternalistic with it? This one I'll let you all. This is a hot topic, dementia and sex. We won't get too much into it because we're running short on time. But there was a recent case involving a husband and wife at the same care facility, and the husband was actually sued by the daughter from the first marriage because he engaged in sexual relations with his wife at the nursing home. Her point of view was my mother didn't have the capacity to consent, and again, the idea was, well, in the moment she did, right? So it was all this wonderful testimony about that, but it really kind of brings it into the idea of something as sort of, maybe that sort of at first blush seems titillating, but, when they looked at the, medical testimony about what intimacy means to someone, even with dementia, like, it's still an important part of your life, even if you have a dementing illness. And at what point do we, take that away from you because we don't think that you can appropriately consent? Again, like all of this, it's another gray area of balancing. And in this case, he ultimately was found, not guilty of any crime, which I think was a nice outcome. But the case was really instructive in sort of bringing up, two things. One, that this is that this is an issue in terms of balancing, and really reminding people that we're sexual beings until we die, right? That it's not that you just get old and that all of that goes away. That we really, if we're thinking about honoring our clients as full individuals with a full complement of human emotions, as sort of uncomfortable as it can make us feel to talk about this, it's still really, really important. Okay, and then from here, 13, right? Okay, so just dementia and advanced directives. So I think we all know that not enough people, and like I said, I was guilty of this myself, do advanced directives. There was a study from a few years ago that said that only 1 in 3 US adults complete any type of advanced directive, even though, all this stuff, and we talked about it with powers of attorney, healthcare power of attorney, living will, the form for Pennsylvania, is freely available on the internet. You can all go and download it right now if you felt like it. But yet, most people don't. Why? Again, this is why the Conversation Project has these resources, because it's uncomfortable to talk about. I think families sort of talk about it in a joking way, like, who's going to pull the plug? But there's more to it. There's more to it than that, right? The end of life is not oftentimes an hour or 2 hours. It can go over the course of months and years in a series of treatment decisions. So it's really important to have these conversations. So because it's this more complicated thing, this is, I think, why people tend not to do it. And as I said before, people usually don't tend to come see me until there's something pushing them to do it. So I want to make sure we get everything. And then in terms of what can you put in your advanced directive, so if we think about Pennsylvania law, your living will, you can say, if I'm ever in an age medical condition, my death is imminent, and I'm permanently unconscious, I do or do not consent to the following forms of treatment that only serve to prolong the process of my dying, and I only want comfort measures to keep me comfortable and free from pain, right? I think we've all seen this sort of idea of a checkbox. I do or do not want cardiac resuscitation, mechanical respiration, artificial or invasive nutrition, hydration, blood or blood products, and on and on and on. Pennsylvania is an interesting state in that we can, to the extent it doesn't violate public policy, write in our advanced directive that we consider advanced dementia to be a condition in which those same treatment decisions can be reviewed. And there are some resources out there for folks who are interested in terms of a dementia directive, right? Because the idea is we wouldn't want somebody, and there was a case, it was in British Columbia, where the judge actually ruled that because the woman was able to open her mouth when they put the spoon up to it, that meant that she was consenting to eat, without really giving any deference to the idea that that's actually and I'm not a biologist, but it's just sort of a reflex, right? that, that isn't actually the measure of whether somebody would consent to nutrition in that case. So you can, again, in Pennsylvania, really use your advanced directive, your living will, as an ability to, stipulate what you would want for you. So it does look like, and a lot of clients of mine will say, oh, it's just a form. Well, yeah, it is just a form, but that's the basic thing. And we can build on it as attorneys, draft it, and make it work for you for your family situation. So we have about 10 minutes left. So I've been talking really fast, so I'm sorry if I've been going a little too fast, but I wanted to get through as much of the material as possible and still kind of get to some of the questions. So why don't we wrap up with some of those questions?
Okay. In terms of guardian versus power of attorney, if the person with memory impairment previously had the power of attorney documents completed prior to impairment, which state they can sign them into a facility, are there any legal ramifications if the person with dementia signs the paperwork in addition to the power of attorney? Essentially, aren't we having them sign a legal document that he or she isn't capable of understanding? And this is, in terms of the document, the contract for admission to the long-term care community.
Right. Well, so there's no requirement that the patient sign the document. And I would agree, if they don't have legal capacity to contract, then, essentially their signature is meaningless. So we do recommend, if you're signing an admissions agreement, you should, if you can, if you have the resources, have it reviewed by an attorney first before signing it. But if you're going to sign it, make sure you're only signing it in your capacity as a legal representative, and make sure you're not signing as the responsible party. But if you push back on the facility and say, I don't think Aunt Tilly should sign because she's doesn't have the legal capacity, and I'm just going to sign as legal representative, that you should not have any issues there. They should not require the person who doesn't have capacity to sign the contract as a condition of them being admitted to the facility.
What's being added as you were speaking, Sherry,
Yeah.
is Regulation 2600, as somebody's reporting, and 2800 require the patient with dementia to sign the contract.
I haven't seen that. I would have to look at the citations, but all the time we just have the agent under the power of attorney sign the nursing home agreement, and I've never been asked to get the patient, him or herself, to sign. Right. I've never been told that they can't come in because they didn't sign.
What if someone is marginal for a power of attorney but too intact for guardianship, and then becomes a co-executor for a spouse who dies? Is the power of attorney for the living spouse then responsible to handle the estate on behalf of the deceased, or does it fall to the co-executor, not the spouse, to manage?
Okay, so let me see. Let me make sure.
You want me to hit that again?
Yeah, let me sure. So okay. I think what you're saying, if I understand the question, the named executor is incapacitated, but that executor created a power of attorney and named an agent. And so the idea is, can the agent act as executor on behalf of the incapacitated executor? I think that's what the question.
Yeah, I think that's I thought that was the crux of the question as well. Yes, yes, confirmation, yes.
I would have to double check. My gut answer is no, that it would be the right to serve as executor is a personal one and can't be delegated away. And when we think about why that is, why it makes sense, is because the selection of executor was made by the decedent, right? So the decedent picked Joe to be their executor, and in the event Joe was unable, Susie would take over. So it doesn't follow that Joe's agent under a power of attorney, Anne, in our example, would be able to take over for Joe, because that was not who our decedent selected. So I believe that the answer is no, the agent doesn't have that. It's the right to serve as executor is a personal decision, and if that person isn't able to serve, then it defaults to the next successor executor. And if there's nobody, then we have to, see who the next of kin are and have, see who's willing to serve and all that good stuff.
Okay. Um, what to do with financial choices when no guardianship is in place, but the elder is being exploited by scammers?
Wow, that is a terrible, terrible, terrible situation. So there's, if you think that an older, so adult is being exploited, you need to call the police immediately, right? Um, Period, end of story. You can also, most of the district attorney's offices also have an elder crimes and financial exploitations unit. You can contact them as well for resources, but that is not something that you can monkey around with. Pennsylvania has a statute in place that protects older adults from these types of exploitive people. The trouble is, and I do a talk on this as well, that the people who are ripping off elderly people often don't have any money, so the victory is somewhat hollow. So yes, you stop the abuse, and they've wreaked all this kind of havoc, and there's nothing to really recover financially. But that should absolutely, if you suspect abuse, if with somebody out in the community, you can also contact Older Adult Protective Services, and they can do. I know at least like, yeah. She's like, when was she going to say it? That is another thing you should definitely be calling, because they can come out. You make a report of need, and they go out and they can figure out what's going on. And that's run through all of the AAA's, the Area Agency on Aging's, in every county in Pennsylvania, except for the ones that are too rural and have to share a AAA. But that is what you should do. And I'm sorry that I'm so sorry that even has to be a question. The financial exploitation of older adults is just, it really just is very, very sad and really makes me angry.
Okay, can you speak about cases where an individual may retain control of the estate, but there's a guardian of person? How do you navigate the challenges on a practical level of an individual refusing to pay for services that they don't want and don't think they need, but the guardian put in place to maintain safety?
Wow. That is a tough one. I mean, it sounds like, you know, it sounds like this is really testing the limits of that tension between personal autonomy and beneficence, right? So the person is saying, I don't need these services, right? And someone's saying, yes, you do. If there is no guardian, if there's a guardianship of the person in place, so that means that there's somebody who has authority to say, yes, you need these services, but it would be really odd to then not also have control of the purse to be able to pay for the services. And so in that case, it's sort of like the guardianship is ineffective, and that might be an occasion to petition for a review hearing because the situation is unworkable. That would sort of be the extreme situation. Now, there's some counties have, mediation. Sometimes we can bring in a third party, like a geriatric care manager, to who the person the older adult might listen to. I mean, I don't want to say we always need to run to court. That's obviously an option. But I've certainly have it, you might even, if they have an attorney, bring the attorney in the loop. I've certainly served that role, not every day, but in some situations where the adult children or family members are like, like she's just not making good decisions. She just won't agree to pay for help in the house. She just won't agree to move to a care facility. And I say, well, she's my client. Let me meet with her. And maybe, she and I having a discussion, we're getting out of that, like we talked about an hour ago, you're not the boss of me dynamic, right? I'm giving them space to feel like they're making the decision, and they do. Now, I'm not saying it's a magic bullet, but I'm just sort of inviting you to see some other alternatives, because continuing to lock horns with somebody is not going to get you the result that you want.
Great. That was a lot of good questions.
Thank you, guys. Thank you so much.
Yeah.
I really appreciate your attention and all the great questions, and I'm just so happy to have been a part of today's symposium. It's really amazing.
Well, I
Thanks.
think we are really fortunate to have you. Thank you so much, Sherry. This was really very insightful and very helpful.
Thank you so much.
Okay.